Hello friends, in the series on the income tax cases, today we will discuss the case of Foseco International Limited versus Commissioner of Income Tax Appeal. This case has been reported in 107 ITR Tribunal at page number 222 and the matter has been decided by Mumbai ITAT I bench and the date of the judgment is 25th January 2023. The purpose of discussing this case is that a lot of problem has to be faced by the assessee. Whenever the assessing officer goes beyond his powers, whenever the assessing officer goes beyond his jurisdiction and tries to look into those matters which he is not required and which he is not authorized by the law. For example, in the limited scrutiny case, the assessing officer tries to cover those matters which are not covered under the limited scrutiny without the prior approval of the commissioner. Similarly, in section 148 cases, the basis on which the case is reopened, the assessing officer tries to give the cautionary which is very general in nature and tries to seek the unnecessary information. Similarly, in the cases of search, when the assessment is done under section 153A and 153C, the assessing officer goes beyond the incriminating material. So all these issues creates a problem for the assessee as far as the litigation is concerned. And one more example in this case is that whenever the matters are remanded back by the ITAT or by the High Courts or by the Supreme Court to the assessing officer on the limited issue of the remand back, in those cases also it has been seen that the assessing officer travels beyond the directions of the tribunal. This is the perfect example of this case. In this case, the assessee was in the business of manufacturing and supplying of chemicals and fluxes as a joint venture. The assessee got reimbursement of user charges of software which was used globally by all the group companies of the assessee named Lotus Notes. This was the name of the software. When this matter came before the ITAT remanded this matter back to the assessing officer to examine whether this user charges received by the assessee comes into the definition of technical services as per Article 13 sub-Article 4 of the Double Taxation Avoidance Agreement between India and United Kingdom. So what was the issue before the assessing officer? That he has to examine whether this user charges comes under the definition of technical services or not. But when the matter was before the learned assessing officer, the learned assessing officer treated this item as royalty. Although he was not authorized to go beyond examining the matter whether it is a technical service or not, but he classified that user charges as royalty. And when the matter came to the CIT appeal, although CIT appeal has coterminous power with the learned assessing officer, but the CIT appeal chosen not to decide the issue. So the assessee was again before the tribunal. Tribunal said that in this case that the matter was remanded only with the limited issue that the assessing officer has to examine whether the user charges which has been received by the assessee and termed as reimbursement, whether this user charges come into the definition of technical services. So the assessing officer has to stick to that only. But the learned assessing officer went beyond that and treated those user charges as royalty. So ITAT said that both the learned assessing officer and the CIT appeal erred in treating the user charges as royalty, and even the CIT appeal did not decided the issue. So in this case it can be said that the assessing officer has done the addition without jurisdiction and ITAT deleted the addition. Friends, this is a very good case because it will help the assessee where the assessing officer tries to go beyond the remand matter, beyond the directions which have been given by the tribunal. At the end of this video, once again I am repeating the name of the case. The name of the case is Foseco International Limited versus Commissioner of Income Tax Appeals, and this case has been reported in 107 ITR at page number 222, and the matter has been decided by Mumbai ITAT I bench, and the date of the judgment is 25th January 2023. Thank you, friends.